A very warm welcome to all. Today, I, Reeya Khanna, am here virtually to explain my topic, Session and Warrant Trial under CRPC. Before we start with the topic, let us understand what does a trial actually mean. The word trial is not defined anywhere in the Criminal Procedure Code. However, it means a commonly understood stage of trial which begins after framing the charges and ends with the conviction or the acquittal of the accused. In simple words, a trial can be defined as a formal examination of the evidence by a judge, typically before a jury, in order to decide guilt in a case of criminal or civil proceedings. Let us understand what are the types of trial in the Indian legal system. The trial of an accused in the Indian criminal law is divided through the punishments of the said committed offence. The trial of the accused for the offence committed by him is divided into four types: session trial, warrant trial, summon trial, and summary trial. But in this particular video, we shall be understanding what session and warrant trial means. Session trial means that when an offence committed is punishable with more than 7 years of imprisonment or life imprisonment or death, then that particular trial is to be conducted in a sessions court after being committed or forwarded to the court by a magistrate. Whereas a warrant trial is when the offence punishable with death penalty, imprisonment for life, and imprisonment exceeding 2 years. A trial in a warrant case begins either by filing an FIR in a police station or by filing it before a magistrate. Now, if we talk about sections in the Criminal Procedure Code, then section 225 to section 237 deals with the trial of warrant cases by the Court of Session, whereas section 238 to section 250 deals with the trial of warrant cases by magistrate. Now, let us understand the procedure of Court of Session in the criminal trial. Chapter of CRPC, starting with section 225 and ending with section 237, deals with the provisions governing the trial before the Court of Session. The Court of Session has to go through 3 stages of trial. Now, the very first stage of trial is in the Court of Session is that basically in the Court of Session, every trial is supposed to be conducted by a public prosecutor as mentioned in section 225. The Court of Sessions is not only accountable in taking cognizance of the offences under section 199, it can also take cognizance of any matter pertaining to the offence of grievous nature. To be more clear and concise, the Court of Session is a court at district level providing its service only for more grave and serious matters. The accused is brought before the court for the proof of his guilt. Now, the first and the foremost work of the prosecutor is to propose the evidence in the court to prove the guilt of the accused, as mentioned in section 226. Talking about case laws in Banwari versus State of Uttar Pradesh, the lordships of Supreme Court have also clearly observed that section 239 lays down that the session court has no power under the Code of Criminal Procedure to drop any charges under which the accused has been committed for trial. He can, in the exercise of powers under section 226 of the Code of Criminal Procedure, frame a charge or add to or otherwise alter the charges as the case may be in cases where a person is committed for trial without a charge or with an imperfect or erroneous charge. If after the consideration of evidence, the submission of accused, the judge considers that there is no sufficient ground for proceeding against the accused, then he shall discharge the accused along with his reasons for doing so, which is mentioned in section 227. Further, if in a case after consideration the court believes that there is ground for presuming that the accused has committed an offense which is triable by the court, then the court shall frame in writing a charge against the accused of the offense, but if not exclusively triable by the court of session, then after the framing of charges, the case is transferred to the chief judicial magistrate or any judicial magistrate of the first class. Talking about section 228, the Bare Act says that the framed charges are to be read aloud and clear in front of the accused with an easy understandable language, and the accused is asked if he pleads guilty for the above mentioned charges or not. Let's talk about the second stage of trial in a sessions court. If the accused is well versed with the framed charges and he pleads guilty, then the judge shall record his plea and convict him. But it all depends on the discretion of the judge. Under section 229, the judge has the power of discretion to convict the accused, but it is desirable that the accused is not straight away convicted. The proper course would be to call upon the prosecution to prove its case by adducing evidence into the court. If the accused refuses to plead under section 229, then the judge fixes a date for the prosecution, examination of witness, production of any document, etc. as per section 230. And then on the fixed date, the judge shall examine the witnesses and evidences may be produced in support of the prosecution. Talking about the third stage of trial and the last part of this particular video, if after examining the accused and evidence given by the prosecution, the judge considers that there is no evidence that the accused has committed the offense, then the judge shall acquit the accused as per section 232. Section 233 says that if the evidence given by the prosecution clearly justifies the court in framing of charges and denial of acquittal of the accused, then the defense counsel will adduce evidence in support of his client. Even accused can apply for the issue of any process. Excuse me. Even accused can apply for the issue of any process for the attendance of any witness or the production of any document or thing, but it should not give a wrong impression to the court of defeating the ends of justice. Now, after hearing both the sides, when the issue arises for giving a closing statement, section 314 of the Act applies and closing statement is given by defense under section 234 and the prosecution gives his closing statement under section 235 of the Act. By keeping in mind all the evidences, the judge makes the final judgment. Now, in this particular video, we understood about sessions trial. In the part 2 of the same video, we shall be understanding about warrant trial and its procedure. Thank you so much.